So, continuing on to our previous discussion, which is the consideration. No consideration can also contracts also be entered without consideration. Usually, consideration is the rule, but then there's an exception for that. We are seeing that we've seen the first out of natural love and affection. If when there's a contract, this can be considered as a consideration. Compensation for past voluntary services. The next example is a promise to compensate wholly or in part a person who has already voluntarily done something for the promiser is enforceable under section 25 subsection 2. Okay. For past voluntary services, consideration need not be I'll give you goods now, you pay me rupees 1000. Consideration need not be something which happens at the same moment. The timing should not be a criteria here. Even for the past considerations, past voluntary services when are done, that can be considered as a consideration for the present promise. We've seen already the consideration can be passed is the rule. So, in order that a promise to pay for the past voluntary services be binding, the following is essential. So, for that to be binding or enforceable, there are some essentials given. The service should have been rendered voluntarily, no force. It should be the services, past services should have been provided voluntarily. The services must have been rendered for the promiser. Okay, consideration is always should be at the desire of the promiser, right? It should be for the promiser. The promiser must be in existence when the services were rendered. Okay, the promiser must be in existence. Obviously, without the promiser, we cannot consider that to be complete, right? He should be in existence, and the promiser must have intended to compensate. There should be the intention to compensate. Okay, do you have done something in the past? Have done so much. He is bound to pay. These sort of things are not valid. Only there should be an intention of the promiser, and it should be done for the promiser, and the services must have been rendered for the promiser and voluntarily. P finds R's purse and gives it to him. R promises to give P rupees 1000. P finding R's purse is the past voluntarily service. No one forced him. He's done that voluntarily, and R promises to pay rupees 10,000. This is a valid contract because past voluntary services can be a consideration. Now, promise to pay time bar debt. What is a time bar debt? There's this law called limitation. Okay, the law gives certain limitation that after certain years this debt is no more enforceable. In that case, suppose we see the same example that is given here. What is the example? A is intended for C. A has to pay rupees 60,000 to C. That is the debt. But the timing of this debt is over. Maybe it has been some years that this debt has incurred and the timing is done by the Limitation Act. Maybe say 10 years, 20 years, whatever it might be, the debt is bad. But now, though the debt is bad, if A signs now, I can, as a final settlement, I can't give you 60,000, but though the debt is bad, I'll pay you 50,000. Now, if A gives this in writing, this is a contract without consideration because there's no more debt now because it is time barred by the Limitation Act. But now, if freshly A gives in writing that I'll pay rupees 50,000 as final settlement, then A will be bound to pay that, though it's a time bar debt. Okay, in case of time bar debt, we say once the debt is barred, there's no consideration. But again, A comes and gives it in writing, he is again bound by it. This is an exception. And then agency. We've seen section 185 of the Indian Contract Act says no consideration is necessary to create an agency. Anyone can create this agency sort of thing. There's no consideration there. However, still it's valid. Completed gift. When the gift is already done, it's over. There's no consideration. This gift is not valid. All this sort of cannot be made. No consideration, no contract does not apply. In case of completed gifts, gift is already been given. Someone has gifted a land or something to others, and now they cannot come back and say there's no consideration and all that. Once the gift is complete, complete. Explanation to section 25 subsection 1 states nothing in this section shall affect the validity as between the donor and donee. Once donation is done, then that's done. They cannot say there was no consideration, we have donated so much and all. And bailment. Bailment is an interesting concept that we'll learn this in detail, and even in your next level, that is your intermediate, you'll have that intermediate, CA intermediate. No consideration is required to affect the contract of bailment. A simple example is in a laundry shop, you have given your clothes. You have given clothes for the laundry. Now it's responsibility. Suppose he's washed all your clothes and returned to you. For that act of washing, laundry washes and you pay some amount. This is one sort of contract, that's fine. But in this case, you're giving your clothes to them. Here the concept of bailment comes. Whenever you give your clothes, or maybe you've given your television for repair, in all these cases, it's the responsibility of that particular repairer, or in case of clothes, of the laundry person to give back the goods to you. Okay, because those are your goods. So this obligation of returning your goods to you is called bailment. For this bailment, there need not be any consideration. Already for washing, you are giving consideration, maybe rupees 100 or whatever. Again, for returning these clothes, laundry person will return you the clothes after washing. For returning these clothes, again you need not give something to him, right? It's his responsibility to give back. Even in the case of repair, it's their responsibility to give back that particular good once it is repaired. That responsibility is what is called bailment. Okay, for this there need not be any consideration. It's their obligation. Once that particular task is done, they have to return to us. And then charity. If a promisee undertakes the liability on the promise of the person to contribute to charity, then the contract shall be valid. Again, charity or donation is the same. Once they promised to do a charity or something, they are bound by that. Okay, they cannot say there's no consideration for us, we are doing charity and all that. Okay, that's a small topic consideration. What we have learned: definition, legal rules of a consideration. It should not be unlawful, and maybe it can be inadequate sometimes. All this sort of rules we've seen, and it can confirm consideration can come from the third party as well. All those legal rules, and we've seen privity to contract. Even a third party can sue sometimes in case of trust, family settlements, marriage settlements, all that. And then finally we've seen exceptions to no contract, no consideration. Natural love and affection can be a consideration, that's an exception. And then you've seen bailment, charity, agency, and all that. Now here, if you go through, there are few, you can quickly go through this summary, and then there are few multiple choice questions, simple multiple choice questions. Consider, if you see the third question, consideration, maybe you already know past, present, or future. Consideration must move at the desire of the promiser. Which of the following statement is false? Must move at the desire of the promiser. That's a true statement. May move from any person. Yes, that's true. Must be illusory is a false statement. Questions. Both consideration in simple term means something in written. Not nothing in written, everything in written, and anything in. It's something in written. Which of the following is not an exception to the rule? No consideration, no contract. Which of the following is not an exception? Love and affection is an exception. Gift is an exception. Contract of agency is an exception. Option A. Compensation for involuntary service is not an exception. These are the answers. Theoretical questions. They said define consideration. We know the definition. State the characteristics of a valid consideration. Okay. It should be at the desire of the promiser. If you see the answer, that is what is given. And second question, no consideration, no contract, comment. You will have to list all that: natural love and affection, agency, bailment, and all that. To form a valid contract, consideration must be adequate. No, it need not be adequate. It can be for lesser value unless both the parties are happy, that is fine. When one party says that contract was made out of force, coercion, and all that, then that's not valid. So simple answers, but then you'll have to elaborate. Quickly go through. We are done with our second chapter, consideration. So under Indian Contract of 1872, we are done with first chapter, nature of contracts, where we've learned essentials of a valid contract, types of contract, and all that. And second chapter is consideration. Now we'll move on to our third chapter in next video.